Welcome to the K&L Gates Working Wise podcast series. My name is Megan, and I am an associate in the Newark office of the firm's Labor, Employment, and Workplace Safety Practice area. In this podcast, I will discuss recent updates on legalized medical marijuana use in the employment context in New Jersey, finishing off with a brief update on what's new in New York City. In 2010, New Jersey enacted the Compassionate Use Medical Marijuana Act, providing certain protections to patients, physicians, and distributors who use, prescribe, and produce marijuana for approved medical purposes. The statute also established a process for registering patients and their primary caregivers as authorized to use marijuana for approved medical purposes. Notably lacking from those protections, however, was any provision addressing how employers should handle employees using marijuana in accordance with this statute. In fact, despite that New Jersey otherwise expanded the statute in 2018 by executive order, the statute continued to expressly state, quote, "Nothing in this act shall be construed to require an employer to accommodate the medical use of marijuana in any workplace." As expected, this language caused confusion in the workplace and in the courts. While the statute made it clear that the Compassionate Use Act did not place any obligations on employers, there was no guidance as to whether other state statutes would obligate employers to tolerate marijuana use now that medical marijuana was legal. The main and obvious concern was New Jersey's Law Against Discrimination Act, which requires New Jersey employers to reasonably accommodate disabled employees, as well as prohibits discrimination against employees on the basis of disability. Therefore, employers, and their lawyers, frankly, were left wondering, even though the Compassionate Use Act said they didn't have to, does the law against discrimination require that employers must abide an employee's medical marijuana use and/or waive drug test or drug use policies as a reasonable accommodation? Eventually, the question made its way to the New Jersey courts. In August 2018, a federal district court answered the question with no. The court found that neither the Compassionate Use Act nor the law against discrimination obligated the employer to waive a drug test requirement for an employee who was using medical marijuana to treat a back and neck injury. Despite that the Compassionate Use Act moved the plaintiff's marijuana use from the criminal to the legal, the court found that the statute was agnostic to its analysis, precisely because it neither imposed obligations on employers nor waived their obligations under the law against discrimination. The court thereafter found that nothing within the Compassionate Use Act changed the line of case law finding that terminations for positive drug tests are permissible. It should come as no surprise that a different court found differently. In 2019, a New Jersey Appellate Division Court reversed a trial court finding that a cancer patient plaintiff had stated a prima facie case for disability discrimination when he was fired due to his inability to pass a drug test because of his prescribed medical marijuana use. The trial court had reasoned that as the Compassionate Use Act did not contain any employment-related protections, the plaintiff had been terminated for failing a drug test and violating the employer's drug use policy, not because he was disabled. Like the district court, the appellate division found that the Compassionate Use Act was agnostic. It neither created new employment rights nor destroyed existing ones. From there, however, the appellate division found that the plaintiff had sufficiently pled that he was fired because he had cancer and had used medical marijuana, and that his employer failed to engage in the interactive process with him after learning that he needed to use medical marijuana to treat his cancer. The court explained that, quote, just because the legislature declared that nothing in the Compassionate Use Act shall be construed to require to accommodate the medical use of marijuana in any workplace does not mean that the LAD may not impose such an obligation, end quote. That said, the appellate division made it very clear that its decision was directly related to the posture of the case. Once past the motion to dismiss stage, the employer may be able to successfully argue that the plaintiff has no claim under the law against discrimination because his use of medical marijuana precluded him from doing his job. On July 11, 2019, New Jersey Supreme Court granted cert on the issue of whether the Compassionate Use Act requires employers to accommodate medical marijuana users. Only a few days earlier, however, New Jersey passed the J. Koenig Compassionate Use Act. Unlike the 2018 executive order, the J. Koenig Act substantially revised and renamed the Compassionate Use Act. Significantly, the J. Koenig Act now expressly states that it shall be unlawful to take any adverse employment action against an employee who is a registered qualifying patient based solely on the employee's status as a registry identification card holder. An adverse employment action is defined by the law as refusing to hire or employ, barring or discharging, requiring an individual to retire, or discriminating against an individual in compensation or in any terms, conditions, or privileges of employment. In addition, if an employee or prospective employee fails a drug test, the employer must provide written notice of the positive drug test and allow the individual to prove that the drug use was for a legitimate medical reason. However, the J. Koenig Act expressly does not obligate employers to permit marijuana use during work hours and allows employers to take adverse employment actions if accommodating the employee's medical marijuana use would violate federal law or cause the employer to lose a federal contract or funding. Accordingly, the J. Koenig Act definitively answers a few questions. No, employers do not need to allow employees to use marijuana or any other intoxicating substance during the workday simply because they are registered medical marijuana users. No, you cannot fire an employee simply because you know he or she uses medical marijuana. And no, you cannot deny someone employment because he or she failed a drug screening test without having further discussions. However, much gray area remains, such as how employers must treat employees whose medical marijuana use at home may affect their ability to do their jobs. That hopefully will be resolved by the Supreme Court soon. On a related note, next year, New York City employers no longer will be able to condition employment on passing a marijuana drug test. While certain exceptions apply, such as for police officers, jobs that require a commercial driver's license, and child care providers, it was the first law of its kind to be passed in the United States. Unlike the New Jersey law, the New York City law prohibits conditioning employment on passing the drug test regardless of the prospective employee's reason for using marijuana. This is a particularly interesting move on New York City's part, considering that recreational marijuana use is not yet legal, although we're getting close. We hope you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.